Hey there, it's Chelsea Rikard from a business law firm in Spartanburg, South Carolina. Something that I come across quite often is when someone is coming to me, they own an LLC and they've owned it for a while, and let's say they co-own it with other people, but they don't have a written operating agreement in place. It is very typical simply because creating LLCs in South Carolina is really simple. You don't have to have a lawyer to help you do it. However, it is strongly advisable to have a written operating agreement in place. Now, if you don't have a written operating agreement in place, essentially what happens is South Carolina law will write in what happens in situations that the operating agreement is designed to address. For example, the operating agreement is going to address things like, what if one of you needs to leave? What if one of you is going to be expelled from the LLC? How do we go about admitting a new member or voting in a new member? How do we consider what is a passing vote on something? Is it unanimous? Is it majority? A lot of people assume that if you own 51% of a business, especially an LLC, that you automatically get basically voting control. That's not correct if you have no written operating agreement. In fact, state law will say everything has to be unanimous. So we encourage people to always have a written operating agreement, even if you've been open for quite some time, because it allows you to dictate a lot of these things for yourself. And 9 times out of 10, they don't necessarily agree with what the statute is going to require them to do. And so they are allowed to change what that structure will be within their own operating agreement.